0600.
Rachel McDuffie for the people.
Assistant Public Defender Liebe on behalf of Mr. Schaefer. Mr. Schaefer, please state your name, sir.
Aaron Schaefer.
Thank you, Mr. Schaefer. Thank you for taking your hat on.
Yes, ma'am.
Mr.
Sorry,
Liebe.
sir. What's that?
Okay, I was talking to your attorney. Have you had a chance to go over this report with your client? It sounds like we're in the same place we were last time.
We are.
I have, Your Honor. I have discussed the report with him. He's working on his community service. It sounds like he had some difficulty finding a place to do it at. I did give him a couple suggestions of where he can look into doing community service, including the Ann Arbor Nature Area Preservation and the Humane Society. He does tell me that he's been testing at Star Center and that he's going to be having them send the results to me and Ms. Straub. I can certainly contact him. That has not yet occurred. It looks like he's giving us thumbs up and saying it has occurred.
Ms. Straub is not here today, so if it was sent to her, I would not have it. All right, we'll just keep seeing if he can get this done. We'll be back here on May 16th, 2024.
May 16th.
Yes, sir.
At 10?
Yes, sir.
And I'm sorry, Miss Washington. You know I don't be like to let you down and stuff. I'm trying. I know that you told me like the holidays would be like a good time, you know. And I did try at church, but they wouldn't really open them. But it was either because I'm doing child support at the same time as this. You know what I mean? So it was either try to work and get the child support, take care of the kids, Christmas, holidays. I'm not trying to make an excuse or anything. I'm just saying. So that's why I probably could have gave a better effort on the holiday, but it was either, you know what I mean? If you understand, I hope.
Well, part of this is to try to get you off probation and get you charged, because if you get it done, you can be done with all of this.
Right.
Miss McDuffie is going to point out something new that I need to know about. Go ahead, Miss McDuffie.
No, I remember last time Mr. Schaefer was here, he said that he was hoping to work out a 5-day straight, assignment with an animal shelter in Belleville. So I just wanted to be clear with the court. There's no restrictions in terms of the county where he has to complete that service. Is that accurate?
That is accurate.
Okay.
I mean, there's a preference, but no restriction. We prefer that it's done in Washington County or even further in our little local Ypsilanti Township, but there is no restriction on it.
Oh, you don't want it to be in Ypsi? It can't be in Washington?
No, I said I would prefer that.
Okay, because Mr. David, he did give me some places in Washington, because my kids live in Washington, so I'm out here a lot, so that'll probably be easier for me anyway. So it's probably like he said, the Ann Arbor. He also told me about the animal place, so I'll make it happen. I'll make it happen.
Good. All right.
Thank you for understanding.
You're
I appreciate
welcome. See you soon.
All right.
Bye-bye.
Yes, ma'am.
You have a good day.
You too. Thank you.
Thank you, Your Honor.
22S00450.
Rachel McDuffie for the people.
Your Honor, Assistant Public Defender Alexis Plumai appearing with and on behalf of...
So I'm here to address the giant elephant in the room. I just don't understand how I got in here without me noticing. Your tail makes me giggle. It's so whippy.
Mr. Evans. And Mr. Evans, if you could state your name after the jail unmutes you.
Thomas Evans.
Thank you. All right. Mr. Evans is here because he failed to appear for his review on January the 11th of 2024.
And we have a new violation, felony too.
We have a new violation or a new felony or both?
I'm sorry, a new violation in the form of a felony warrant that I think he's getting rained on this afternoon.
What is that charge?
Those charges are, one moment, I just had to pull it up. Let's see, that's case 24B 1020. And count 1, firearms discharge in or at a building causing an injury. Count 2, assault with a dangerous weapon, felonious assault. Count 3, CCW. Count 4, firearms possession by felon. Count 5, felony firearm.
All right. What's the date of that?
That offense date is October 10th of 2023. And yes, and he's in warrant status at Wayne County, it looks like too.
Well, that's in between
I believe the offense date on that is actually the 28th of December.
Oh, did I say that
Oh.
wrong? I'm sorry.
Okay, all right. Wow.
Yes,
Okay.
I don't know what type of dyslexia is happening right now because those
Okay.
numbers weren't even right. Sorry about
All
that.
right, thank you. All right, what would you like to say about bond, if anything, at this time?
Your Honor, just with regards to the failure to appear, Mr. Evans seemed to be under the impression that he was not on probation. So I just wanted you to confirm that on the record. I didn't see anything to indicate that he was not on probation. And because I am fairly certain that he will be held on those new charges when he's arraigned this afternoon, I'm not going to ask for anything with regards to bond and just request a violation of probation hearing date.
It looks like he was sentenced on May 25th
Yes.
to 24 months of probation. I'm not
Yes.
what.
And that's what I saw as well. He wanted me to have the court confirm that for him on the record.
Okay.
Your Honor, if I may.
No, sir. All right. I think that the violation of probation documentation is not going to need to be filed in this matter still anyway. So what I'm going to do is schedule this for March the 28th. And then at that time, sir, you'll have your actual counsel that's going to be with you, and you and your counsel can talk and provide me with whatever information you want to provide me at that time, okay?
I can ask a question.
What's the question, sir?
I was sentenced to probation when?
May 25th.
I was in here doing, I was sentenced to a year in the county, which was the maximum penalty on the case. And I chose to do the whole year instead of going to treatment. So
Well, that's what you wanted to do.
that's what I did. I did the whole year.
All right.
So after I maxed out on the case, it should be no other recourse.
March the 28th.
It ain't no thing to do my thing, it's what I did the best. I copped that crib and bought 2 chains and then I hid the rest.
Welcome back to Time Served, the channel that scans the docket so you don't have to. And today we are going to hear the case of Mr. McMillan, who is a perfect example of why we must be tough on felony drug offenders because they never learn. Then we are left with criminals who are addicted and reoffend because there are no consequences. And in this particular case, Prosecutor McDuffie recalls his 3 prior felony drug offenses dating back to 2014 that were pled to misdemeanors. So now we have a defendant that has never truly paid for his crimes, knows there are 0 repercussions, so what does he do? How about missing over a dozen urine screens, and when he does show up, lights up brighter than a Christmas tree? Judge Washington is not the toughest on drug offenders. However, instead of releasing him with probation so he can continue his misdeeds and reoffend, just continue the cycle, she did something that caught me by surprise, I must admit. So tell us what you think by leaving a comment. And don't forget to hit that like and subscribe, set your notifications to all, and never miss the dynamic duo from the 14th District of Waukesha County. I'm Time, and you've been served. Let's roll, nerds.
Court will call the case. I think we have to call it back in session.
Court to be court is back in session. Honorable Ray Washington presiding.
Thank you. The court will call the case of the state of Michigan versus Devon Ellis, case number 23 FB 1258.
Rachel McDuffie for the people.
Assistant Public Defender Allison Miller. I'm here on behalf of Devon Ellis, who sits to my right. Mr. Ellis, can you state your name for the record?
Devon Ellis.
Thank you. All right, Mr. Ellis, you're here today because a violation of probation report was filed alleging that you tested positive for alcohol via ETG on February 23rd, 2024 in violation of the no alcohol condition of your probation. You're entitled to have a hearing in this matter, at which time, if it is shown that you in fact did violate the terms of your probation, you could be subjected to this is a technical violation, so you'll be subjected to 5 days in the Washington County Jail. That is what is being recommended at this time. I think that's probably more due to the fact that Mr. Ellis continues to deny use, and then he had another incident that does not rise to the level of a violation, but his number had been called a couple of times where he needed he made an excuse as to why he could not go and test. And at this time, I think there's some frustration going on. Having said that, what would your client like to do?
Your Honor, at this time, Mr. Ellis does want to admit to the violation.
Please raise your right hand to be sworn, sir. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. You may lower your hand. Sir, you understand you have a right to have a hearing in this matter, is that correct?
Yes, ma'am.
And you wish to waive that right and you're going to admit to the violation?
Yes, ma'am.
So is it true that you tested positive for alcohol on an ETG test for February 23rd, 2024?
Yes, ma'am.
I find that there's a knowing and willing admission of the violation. Are you satisfied, Ms. McDuffie?
People are satisfied.
Thank you. So what's going on with your client?
Your Honor, I've talked quite a bit with Mr. Ellis, and I guess the first thing I want to know, or want to let the court know, and I will address, what's going on with him specifically. I just want to let the court know that he is taking this very seriously. He's been in a lot of contact with me, as soon as he tested positive. The conversations that I've had with him recently compared to maybe when I first took on his case, it seems like he is doing well, and he is really wanting to do the best he can. There was some confusion because I know when he went in to test that day, the breath test was negative, and so I think he was adamant, I haven't had alcohol right now, and I explained to him the ETG can pick up farther back. He doesn't remember consuming alcohol. He's pretty sure in February he didn't, but he's on a lot of different medications. I don't know if, for example, codeine, I don't think that leads to positive alcohol.
No. What leads to positive alcohol? Alcohol.
And I told Mr. Ellis, and he's still thinking about if he did consume alcohol in February and if that's positive. I told him if it's possible, I told him he needs to just, be upfront with the court. If he slips up, the court knows that can happen when someone's recovering. It did look like his tests were negative for substances, which I know were the underlying cause of this case. He's really, doing well overall in recovery. I think he's brought here proof of the meetings he's been going to with friends. It's called Friends at the Little House Recovery Center, where he's been attending meetings. He's really on track with community mental health. You're staying really active with them, right? And your mom confirmed that. So that's all going well. And I know this, I think, was the day after this positive test was the day after you were seen last. And so
yes, he was sentenced on February 22nd and he tested positive the next day.
And Your Honor, again, I just would emphasize, at least Mr. Ellis did say that the day of he didn't blow a zero. So I would hope that he didn't consume alcohol that day or the day of the positive test. But I think, again, with the underlying charges, it seems like he has tested negative for drugs. So he's doing well on that end, and that was what this charge was all about. Of course, he needs to abide by the conditions and not consume alcohol, and if he is struggling with that, he needs to also seek help with that. But I do really believe he right now is doing the best he can. I know he, in the report here, it mentions he tried to reschedule testing. Him and I had more conversations that that's just not going to be possible. I know the funding again was an issue, and I think testing popped up several times in that first week, so it was kind of an issue of funding. His mom told me he's been approved now for Social Security. That should be coming in very soon. So, funds will not be an excuse going forward. Mr. Ellis and I talked. It's very clear to him now that he can't, reach out to Agent Straub and request not to test or to reschedule. That he's absolutely got to be there when his number comes up.
Well, I mean, sometimes there are exceptions to the rules, but the problem for Mr. Ellis is that he's been having this issue since the beginning of this case. We, on December 5th, had to issue a bench warrant for him because he simply, it looks like, failed to appear at that time. And then the warrant was recalled. He had to admit at that time the felon to test. This was on January 18th. He had not been testing since November to January. So he then got reinstated with testing and was to test within 24 hours. And I scheduled him for sentencing. In the interim time, he had another violation and got another one. Then he got that one recalled by the magistrate. And then he failed to comply again. I had to issue another bench warrant. We finally got him sentenced, and then the next day he tested positive. So his history is a part of the problem.
I totally agree, and I think Mr. Ellis agrees that his history does not help him today. The court has given him many chances. That's why I would just highlight that for me, his demeanor since I've started working with him has just been different to what I feel like his record reflects. Like this morning, he called me several times, texted. He was so worried that he was running late. He said, "I'm going to be there at 10:15." And I said, because he had caught I think had missed one bus, but jumped on the next one as soon as he could. And I said, "Don't worry, you're going to be here. It's fine." And of course, he shouldn't have ran late, but he was just so worried that he wouldn't be here right at 10 when the hearing was set for. And I said, "It's okay. I think your case won't be called, but just get here as fast as you can." And he's here today in person. And I had incorrectly told him it wasn't. I thought that the sentencing would be in person. But, to be on the safe side, him and his mom were here in person. And, I think not the positive test that happened on the 23rd, but everything besides that in the last month, to me, points to that he is taking it seriously now. And I just would hate to see him get derailed now when it seems like he's putting in an honest effort and doing everything he can, especially with, mental health. And I think he just has got to get this testing, and I understand there can't be any more positives. And if I could make a recommendation for what we'd ask for today, is that if the court would consider adjourning the sentencing with the understanding that there cannot be any mistests or any positives between now and the sentencing, and that would be the defense's request today.
Ms. McDuffie?
So the court, I would agree, is absolutely correct with respect to the history and what role it plays here. And what I see that concerns me is that this is Mr. Ellis's third controlled substance felony that has been reduced to a misdemeanor, and that goes back to 2014. Now, I can't control what's already happened and deals that were made by other people, but I'm concerned that's actually part of the problem, which isn't his fault that he got those deals, with him not understanding the seriousness of not only the criminal offenses, but his own substance abuse problem. I think there's a minimization that's occurred in the system when things are quote unquote just a misdemeanor. Not that that's not serious, but I don't have any testing updates since that February 9th report. So all I know is that he had this alcohol positive. But on that report, after that second bench warrant for not testing, those were benzos that showed up positive. And I don't see any prescription. Maybe that most recent report reflects it, but I don't know if we have anything to reflect the prescription. So if he's going to be issued a bench warrant for future positives, we might need to address that. I didn't see benzo show up anywhere else, but he hadn't been testing either, so who knows? Just so that everyone's aware, we have a new warrant request for Mr. Ellis. However, it's not going to be a violation because that offense date is, I think, not only prior to sentencing, but maybe prior to his arraignment in this case, is October of 2023. So the offense date is older, but I don't think he got arraigned until possibly being picked up on that. But so I realize that's a bit older, but even that, that's something that's involving multiple controlled substances, open intox, etc. So Mr. Ellis's problems, I think, are deeper than he comprehends. And he has said repeatedly that he doesn't have the money to test. I understand there's an expense and money doesn't come out of nowhere, but that's not going to be a reason that we leave him using, right? So he has to figure something out. The answer is to stop using, but you still have to test so that we can see that. And I don't know I don't know I take Miss Moeller at her word that she's looking at a more recent report than the one I have, and that those have been negative for substances over the last month.
Could you send that report to the both of us, Ms. Moeller, if you're saying?
Your Honor, I was just pointing to the report from Ms. Stroud from March 6th, where it says the agent allowed him to test the next day on February 28th, at which time he was tested for drugs only and the test was negative. So I'm sorry if I misspoke. I only meant that. That's the only test I know if that was negative for substances. I was just saying there was a negative for substance. And Mr. Ellis did say he tested. I tested in March. I don't know the date of that exactly. But I don't have a report to that.
11 and 6. Who's the author of the report you have, Ms. McDuffie?
Let me pull that up. The community corrections report that I have for him from January was Agent Wild.
Oh, well, you know what, Ms. Johnson, are you able to look and is she here? She is. Hello again, Ms. Johnson. Are you able to look and see if they show testing for Mr. Ellis in the system?
I can pull up community corrections drug testing results right now, Your Honor.
Thank you.
So he was negative on March 3rd. He missed on March 13th.
So you missed yesterday.
What does February look like? Because I think the last report date we have was February 9th was the last report date that we had.
So February 12th, he missed. February 16th, he missed. February 22nd, he missed. February 23rd was a positive ETG. February 27th was a missed. February 28th was negative. February 29th was missed. March 4th was the negative, and then yesterday was a missed.
Thank you.
Thank you so very much.
You're welcome, Your Honor.
That speaks for itself, Your Honor, that we obviously can't be assured. I appreciate that one or two of those in there was negative, but when it's following a series of missed tests, given his history, there's no assurance whatsoever that he's not using.
You may speak, Ms. Muller. I have the same concerns as the prosecutor. He's testing when he wants to test.
Your Honor, I do know yesterday, and this isn't, you know, an excuse for the whole day, Mr. Ellis was in court with Judge Simpson yesterday. And so he was preoccupied by that. And I know, 14A is right there, but it sounds like. So he didn't call to see if his number was called. He was preoccupied by court yesterday with Judge Simpson and knew this was coming up today. Your Honor, I know those are some missed tests. That is concerning. And this is not he tested, much more than he had been. Of course, he needs to be going every time. I stress that to Mr. Ellis. He knows I cannot miss testing for any excuse. And so we apologize to the court that those tests were amiss. There's really no excuse after kind of the history that we've had here. Again, the defense's request would be to adjourn the sentencing out with the understanding that Mr. Ellis cannot miss one more test between now and sentencing and cannot have another positive. I should add too, I don't know if that helps in any way. I know Mr. Ellis needs to be testing for substances, so there's no way to remove that. He's has expressed that he'd be willing to do a strand tether or a sober link to help with the alcohol testing, or if the court would consider putting that on in lieu of the alcohol testing. But of course, he needs to be testing for substances, so the request would still be to allow him to do that and adjourn sentencing out.
And what are you requesting, Ms. McDuffie, so we're clear?
Your Honor, I appreciate Ms. Mola's advocacy and hope and confidence in her clients. I truly do. But when we were here on February 22nd, the court said that if he missed another test after that point, a bench warrant was going to issue, I believe. So Mr. Ellis is not in a situation where he can even make that promise that he's not going to miss another test. We started out trying to get to his sentencing with 17 of them that he had missed at that point, and he's just missed ever since then. And when he hasn't missed, for the most part, he's tested positive for something, with a couple of exceptions in there where he tested negative. This problem is over his head at this point. He doesn't have control over his use or his testing. And I don't know what the long-term answer is, but the short term is not to trust him to do it moving forward.
Anything you want to say, sir?
That I can do it. I had quit marijuana. I had quit cocaine. I had quit like everything, and I still attend meetings. I'm not making no excuse or anything, and I definitely think I can still finish this probation out because I'm so confident, and then I'm still around positive people, and I let a lot of stuff go these past months and stuff like that, and I no longer do drugs. That was coming from doing it a lot, and I totally don't do drugs anymore. And
how am I supposed to know that, sir? You're not testing regularly.
It was a money issue, but which is not going to be no issue again. And I will continue to come to court every time y'all want me to, as scheduled. And I just want to stay in a positive mind state that I can do it, and I know I can do it for sure.
So part of the problem I have is I don't know how 5 days gets us much of a difference in his situation. Not that the recommendation is wrong. That is what we're allowed to do at this time. My thing is that he actually needs probably inpatient treatment, but I'm gonna let him tell me whether that's true or not. And sir, let me tell you, this test is considered a positive test. If you don't go, you're positive. Do you understand?
Yes, and I'm so sorry about that, Your Honor. I apologize to the court.
I'm not gonna sentence you today. I'm gonna wait and see if you miss another test or you drop positive. I think you'll let me know in less than 2 weeks, so I'm gonna bring you back in 2 weeks on March 28th.
Thank you so much, Your Honor.
At 11 a.m. in person again.
I will definitely be here.
That's for the sentencing. You're welcome. Like your mom?
Yes.